starting in 5 seconds. Sir, I am glad our finance minister is here. According to his, nothing is rising very much. After the budget, only marginally here and there, certain items have been affected. The items on which he has cut taxes in his budget are absolutely free from the price rise. Sir, I had a better opinion of Honorable Minister. I have known him for many years and he is a knowledgeable person. All I say is that the budget has a negative impact on the prices, that is to say, it is pushing up the prices irrespective of whether a particular item has registered a higher price or a lower price. The trend is one of growing inflation, escalating inflation. Now, sir, in the last financial year, according to the wholesale price index, inflation was 20%. It appears from whatever material we have collected from various sources, including his sources, that this year inflation is likely to be at the rate of 30%. During the first few weeks of this calendar year, the prices rose by 32.7%. In the post budget period, the prices jumped up by 12.2%. In the post presentation of the budget, our calculation is on the basis of the material that we get from the government and other sources, that it has increased by more than 5%. This is since the presentation of the budget in June last. Now, sir, this is the position. Here, sir, I must point out that the middle class is particularly hard hit. According to the studies that we have made, on an average, a middle class man has to spend rupees 55 to rupees 60 per month more than what he was spending immediately before the budget to maintain the pre-budget standard of living. Now, these are gathered from the economic data, and many papers have also written on this subject. Not, sir, what I find is that the essential commodities of common consumption are constantly registering rise in their prices, which hit the common man. This is one of the most disturbing features in the present inflation, but so far no step has been taken. One of your election slogans was that you would hold the price line, but exactly the opposite you have done. Exactly the opposite is happening here. The price is unprecedented now, except for 1 year during the whole of the last 2 decades. This inflation is unprecedented and it is at an unprecedented rate. This is a strange thing. Now, sir, I need not go into sugar and other things, but I will give my suggestions. Middle class people, particularly, and all other sections are hit at the same time. But paradoxically, sir, the just growers and the farmers are losing. The jute prices have collapsed, and you can understand what will happen to them. Now you have given here the export duty on turmeric. The prices have collapsed and you have put rupees 2 per kg or so as export duty or rupees 200 or so per quintal that you should have avoided. What is now needed is that physical possession of the essential commodities should be there. How do you do that? It has been stated very clearly and earlier. Also, I repeat that without physical possession, you cannot ensure supplies. Without physical possession, how can you ensure supplies? And that can be done by two ways. First, by nationalizing certain essential commodities. Why textiles should not be nationalized? Why sugar should not be nationalized? Why can't these be nationalized so that you can have physical possession? Sir, the standard cloth production has gone down and the superfine and finer varieties of cloth have been produced to make super profits by the big mill owners. This is number one. Then, secondly, commander all the stocks from such industries in order to distribute them. These are the two essential things. Sugar and textiles should be nationalized. Nationalization should take place, but they will not do that. Then, sir, deficit financing is there. You have to curb deficit financing. You have said that deficit financing would be of the order of rupees 1400 crores. It never happens. I think deficit financing would be well over rupees 2500 crores. Then distribution through fair price shops. It is a myth now. We had been hearing that within 6 months it would have been done, but nothing has been done during the entire Janta rule. Today, vigorous efforts should be made to improve the distribution system that has become a myth. The number needed is more in the villages and in the towns. Popular committees should be attached to the distribution centers or shops. That is very important. Money supply should be checked. These are the causes which have given rise to price rise. Distribution expenditure by the government must be cut. I gave you one example. I can give you many examples also. Stop. Starting in 5 seconds. Mr. Deputy Chairman, Sir, in regard to the Finance Bill, we have submitted detailed amendments and hence I shall confine myself now to the general policy behind the Finance Bill. The detailed proposals we shall deal with when the amendments are taken up. Sir, in presenting the finance bill based on the budget, the finance minister has delinked the price rise of petroleum and fertilizer from the budget proposals. He has delinked the price rise to the extent of rupees 2700 crores. This petroleum and fertilizer price rise, coupled with the imports of about rupees 204 crores in the railway budget and rupees 445 crores in this budget in a full year, which comes to a total of about rupees 3400 crores, have had a very strong effect on the prices. These budget proposals have increased the inflationary price pressure in the country. It is clear that the inflation this year will be a two-digit inflation. The national newspapers have predicted a 30% price rise. Some economists have said a price rise of 15 to 20% is inevitable, as the finance minister has delinked the petroleum and fertilizer price rise from the budget. He has also delinked the anti-inflationary proposals from the budget. The budget is the weakest so far as the price policy or the anti-inflation policy is concerned. We have very great and an almost unprecedented price rise. I think the government had already said that the prices of petroleum products have risen by 34%. The price of oil has risen by 25%. The prices of all other commodities have risen by 10.5%. This is government on admission. This is government's on admission. Hence, in view of this unprecedented price rise, we had hoped for a massive, determined, and resolute policy for controlling the prices. In the short run, you control the prices by strengthening the public distribution system. In the long run, you control the prices by increasing production. But so far as the public distribution system is concerned, there is not much emphasis on it in the budget. One of the colleagues of the finance minister has said in one discussion that he does not believe in any control. He said he believes in self control by the trading people here. This kind of a statement creates confusion. But if we have to stop the price rise, there should be a strong public distribution system. But in our country, we have only 2.4 lakh fair price shops for a population of 700 million. Therefore, there has to be budgetary support to strengthen our public distribution system, and we have to have greater budgetary support for essential commodities whose shortage we are having the allocation for textile mills in the public sector, which are to produce controlled cloth, has also been reduced. Government should have a very firm policy so far as prices are concerned, so far as speculators, hoarders, and black marketeers are concerned. Prices are rising, stocks are being built up, and inventory is going up. Speculation is taking place by money from two sources, one from regular bank money and the other from black money. With regard to regular black money, after the finance minister nationalized six banks, we have control over 91% of the banking resources. Still, some credit is going to speculators because there is a cultural norm that whoever was getting credit will go on getting credit. Therefore, on credit policy, there has to be greater surveillance and greater money check so that those who hoard do not get credit. Otherwise, this anti inflationary policy will not succeed. This is so far as white money going to speculation and hoarding is concerned. So far as black money going into hoarding and speculation is concerned, on black money, the Vanchu committee was there. It had pointed out that 8,000 crores of rupees of black money were circulating into the market. Somebody said that it is rupees 20,000 crores, and somebody's estimate is still higher. It is said that there has been a tax evasion of about rupees 1400 crores. Therefore, on black money, the finance minister has to take strong and firm action. The raids are not taking place, and sometimes when the raids take place, there is something flashed into the newspapers, but later nothing comes out of it. Therefore, strong and firm measures are to be taken so far as black money hoarders and profiteers are concerned. On black money, the question of bearer bonds was also mooted. It was not successful in Cyclone. About the steps, I would not ask the finance minister to disclose to the House, but I would ask him to take them as he did it in the case of nationalization of six major banks for which he deserves credit. So, in black money, I hope the finance minister will do something very firm without giving any warning to anybody about the steps. Stop. Starting in 5 seconds. Mr. Vice Chairman, Sir, I rise to support the finance bill. I am conscious and aware of the limited authority of this House in respect of the bill, in which the finance bill is the highest importance. In terms of Article 109, this House is entitled only to make recommendations to the Lok Sabha, and it is left to the exclusive discretion of the Lok Sabha to decide and take such decision as it wishes on these recommendations. Article 108 excludes discussion on the money bills completely from the purview of a joint session. Sir, whatever may have been the compelling reasons and grounds that may have commanded to the founding fathers of the Constitution, while they limited the authority of this House in respect of the money bills after so much flow of water in the Yamuna in the last 50 years. A time has now come when it must be realized that in the federal polity or in the quasi federal polity, the finances of the center have become exceedingly important for the states, and the collection of the revenues of the center is by no means an uncomplicated process, and the disbursement of these resources is by every standard complicated, exercising larger participation and a larger authority for the states through this house in the financial matters. But, sir, more about it at an appropriate time. I have voiced my opinion on this issue at this juncture because I thought that ultimately, if we were to recommend anything to the Lok Sabha at present, the bill having come from the Lok Sabha, as it has left very little for us to say in this matter. That is a very serious matter. Sir, I have gone through the criticism which has been leveled on the finance bill, having read the debates in the Lok Sabha and having carefully listened to the criticism outside Parliament. I am inclined to consider that there are quite a few chronic critics of all the measures which my party may evolve in all the finance bills and the budgets, and these are such critics as have in fact not yet reconciled to our basic economic philosophy and do not share with us our belief and faith in a mixed economy. To us, a mixed economy is the very basis and foundation of our economic system. In fact, the concept of a mixed economy was well conceived by Pandit Jawaharlal Nehru. We ardently believe, as an article of faith, that the parliamentary institutions could flourish only in a mixed economy. They are coextensive. In fact, we believe that they are not only coextensive but also coterminous. Therefore, sir, the criticism of my communist friends who want complete extermination of the private sector and my other friends who subscribe to the theory of one measure or the other measure, not because they quarrel with the measure my friend has provided for in the budget or in the finance bill, but in fact their quarrel with us is on a much larger issue. That quarrel they can continue till the doomsday, but we are not going to yield so far as that aspect of the matter is concerned. The private sector and the public sector both have to play a vital role in the economic development here. But, sir, as to those who accept the basis of the mixed economy, such critics do not seem to have fully realized the enormity of the grave problems and the economic distress in the midst of which the budget and the finance bill have been presented by the finance minister. Sir, one were only to evaluate objectively the whole of economic chaos into which the finance minister was put when he prepared his budget and the finance bill, the position would be a little clear, sir. The economy was at its beam end, and the predecessor of the finance minister had pushed it into an absolutely unenviable situation. What was the situation, sir? The growth in the agricultural production was down by 10%, that in the industrial production was down by 1%, that in the gross national product was down by 3%, that in employment in the organized sector was also down by 3%. The only thing which had grown up was inflation by 20%. There was an unprecedented spurt in the money supply in the midst of unprecedented decline in supplies. There was a period of inflation on one side and shortages and more shortages on the other. There was a shortage of power because there was shortage of rain, and there was shortage of coal. There was shortage of coal because there was shortage of wagons. There was shortage of wagons because there was shortage of steel. There was shortage of steel because there was shortage of power, coal, and wagons. The situation was an extremely horrifying one, sir. That was a period of political instability and indiscipline which led to total industrial unrest, and to accentuate this situation, an extremely thoughtless and an indiscriminate budget was presented here. Stop. Starting in 5 seconds. Relying on the decision of this court in Indrasani case, the learned counsel has poured that economic criteria cannot be the sole basis to provide reservation. He would further submit that a class should be homogeneous, have a common origin, and have the numerical strength. The EWS created by the amendment in question does not fulfill any of the criteria and hence cannot be called a class for any state action, particularly the affirmative action. He further emphasized on this argument by intensively reading the opinion of Justice Sahni in Indra Sahni case. The learned counsel has further submitted that the amendment in question fails on all the basics of equality code, because if poverty is the rationale behind it and it aims at providing jobs for the poor by the poor way of reservation, then the amendment fails to address as to how the poverty of the forward class is different from that of the SCs, STs, and OBCs. Hence, the amendment in question fails the twin test of rationality and annexes and violates the basic structure of constitution. Learned Senior Council has submitted that in India reservation formed a special part of affirmative action. It is within the larger affirmative action circle that reservation finds its place. Drawing analogy with countries like USA, Israel, and Germany, the Learned Council has submitted that indeed affirmative action can be an answer, but it is not the only answer. There are therefore many ways of addressing the issue of economic disadvantage other than reservation, as has been done by these countries. He would further submit that the limit for such reservation cannot exceed 50% except in cases where compelling reasons arise. Arguing on the Equality Code, Learned Council has relied on the classification laid down by this code that the present amendment neither has any reasonable classification nor such classification has any nexus with the object to be achieved, hence is violative of Article 14. Entire list of reserved categories of citizens is caste based, and the amendment did not include any metric or indicator, ignoring the marginalization criteria entirely while granting reservation. He has also quoted the works of John Searle to submit that each person has the same indefeasible right over every claim. One law for lion and ox is oppression. The Learned Senior Council, quoting William Blake, has contested the amendment. First, granting reservation to upper caste is violation of the basic structure of constitution, as the basis of reservation must be rooted in identified past discrimination which impeded access to public administration and education opportunities. Relying on the decision of this court in Indra Sani case and judgment of the Gujarat High Court in Dayaram K. Verma, wherein similar reservations on the basis of economic criteria were quashed by this court and the High Court respectively. He has submitted that economic criteria cannot be the sole basis for providing reservation, and the reservation cannot exceed 50% limit. Second, he submitted that reservation in the favor of forward class violates the basic structure of the constitution and is therefore unconstitutional. Third, classification of EWS is neither reasonable nor valid. The reason for providing reservation to SC, ST, and OBC communities was historical and perpetual discrimination and stigmatism. It was the structural barrier that kept them from the mainstream. Reservation cannot be used as poverty alleviation scheme. Hence, such classification violates the Equality Code under Article 14. Fourth, the amendment in question fails the width test laid down by this court in M. Nagarj, as there are no limitations or indicators that have been devised to identify the people falling under the EWS, whereas for each category, be it SC, ST, or OBC, the Constitution is overseeing the reservation by virtue of Article 366. Hence, the amendment in question fails the guided power test. Learned Senior Counsel, while placing reliance on Constituent Assembly debates and decisions of this court in Keshavanand Bharati case, has argued that the 103rd Amendment violates the basic structure of the Constitution as it changes the identity of the Constitution. He would again submit that providing reservation solely on economic criteria is against the decision of this court in Indrasani case and also against the facade of democracy, as democracy ought to be representative. The learned counsel would argue that economic criteria is transient in nature, whereas the inclusion of backward classes under Article 16 bracket 4 was on the ground of historical exclusion. In our society, discrimination finds its root in caste, religion, race, etc., and not in economic condition of a person. The classification under Article 14 has to have reasonable nexus and intangible differentia, which the amendment in question, because of all the aforesaid reasons, fails to achieve. He has also submitted that indeed forward class must have faced some discrimination, but the intensity of discrimination is not enough to justify reservation. To support his summation, he has relied on the judgment of this court in Madhavrao Sindhi case. Stop. Starting in 5 seconds. The next argument is the argument based on the difference between the words within as found in CRZ1 as contrasted with the word in CRZ2. We are called upon to employ a purposeful interpretation, bearing in mind also the distinction in the words used. Much reliance has been placed on the judgment. The sad matter arose under the coastal regulation notification issued in the year 1991. The MOEF granted permission to the respondent therein for construction for setting up of a marine terminal facility near the seashore for receiving and transferring VCM, which was one of the raw materials for manufacturing PVC. Under the terms of the 1991 notification, certain activities were prohibited under paragraph 2. They included manufacturing or handling or storage or disposal of hazardous substances as provided therein, except transfer of hazardous substances from ships to ports, terminals, and refineries, and vice versa in the port areas. The question fell for consideration as to the interpretation to be placed on the words in the port areas, we feel advised to refer to the following portion of the judgment reported in the Law Reporter. It was contended by the senior counsel for the appellant petitioner that transfer of VCM in CRZ area is completely prohibited and VCM cannot be carried through the CRZ except in the port area. Their argument is that VCM can be brought onshore by pipeline to the port area but not in the CRZ area. The arguments of learned senior counsel have put in issue the scope of expression except transfer of hazardous substance from ships to ports, terminals, and refineries, and vice versa in the port areas, which was added in Para 2 on 9th July 1997. We are called upon to ascertain the true meaning and intention of the executive in bringing this exception. In the original 1991 notification, there was no exception clause. It appears to have been added for the purpose of enabling transfer of hazardous substances from ships to ports, ships to terminals, and ships to refineries, and vice versa. Is such transfer of hazardous substances confined to terminals and refineries located in the port areas? The answer in the affirmative may make the said provision unworkable and would also result in absurdity inasmuch as the hazardous substance would be brought into the port. It is well settled that if exception has been added to remedy the mischief or defect, it should be so construed that it remedies the mischief and not in a manner which frustrates the very purpose. Purposive construction has often been employed to avoid a lacuna and to suppress the mischief and advance the remedy. It is again a settled rule that if the language used is capable of bearing more than one construction, and if construction is employed that results in absurdity or anomaly, such construction has to be rejected and preference should be given to such a construction that brings it into harmony with its purpose and avoids absurdity or anomaly, as it may always be presumed that while employing a particular language in the provision, absurdity and anomaly was never intended. Notwithstanding imperfection of expression and that exception clause is not happily worded, we are of the view that by applying purposive construction, the expression in the port areas should be read as in or through the port areas. The exception in para 2 bracket 2 then would achieve its objective and read except transfer of hazardous substances from ships to ports, ships to terminals, and ships to refineries, and vice versa, in or through the port areas. This construction will be harmonious with para 3 bracket 2, which permits the activity of laying pipelines in the CRZ area. On the one hand, the learned counsel for the appellants would place considerable reliance on the view taken by this court. Per contra, learned senior counsel would submit that the aforesaid decision turned on the facts obtaining therein, and in particular the expression in the port areas, whereas the language used in paragraph 8 bracket 2 and also the context should persuade this court to place an interpretation advancing the object of a notification, such as the 2011 notification. A perusal of paragraph 36 of the judgment would show that the contention of the appellant therein was that the transfer of the raw material in the CRZ area was completely prohibited and it could not be carried through the zone except in the port area. This court understood the terms of the notification to be that it permitted transfer of the hazardous substances from the ships to the ports, ships to terminals, and finally ships to the refineries. The vice versa was also found to be within the contemplation of the notification as permitted activities. The court posed the question whether the transfer was to be confined to refineries and terminals which were located in the port area of the terminal there. Stop. Starting in 5 seconds. I rise to commend the Constitution Amendment Bill seeking to have an impartial and multi-member election commission. The object of the bill is simple but important. It seeks to provide for a multi-member election commission, removal of the members of election commission including the chief election commissioner from office only in like manner and on like grounds as a judge of the Supreme Court, and powers to the election commission to make rules for regulating its own procedure, etc. The present position under Article 324 of the Constitution is that the superintendent's direction and control of the preparation of the electoral rolls for and the conduct of all elections to Parliament and to the state legislature and of the offices of the state legislature and of the offices of the president and vice president are vested in the election commission. Clause 2 of the article visualizes that the election commission consists of the chief election commissioner and such number of other election commissioners as the president may from time to time fix. But unfortunately, the commission continues to be a single member body in spite of the demand in Parliament, the press, and the public platform. The chief election commissioner, the words election commissioners are incorrect, is the sole authority in all matters pertaining to preparation of the electoral rolls and conduct of election of the president, the vice president, and members of parliament and of state legislatures. In this largest democratic electoral system in the world, the entrustment of one single individual with this task, which has a great bearing on the functioning of democratic institutions, is not desirable. What are the duties and functions entrusted to the Election Commission under the Constitution and the law? The functions of the Chief Election Commissioner are: he superintends, directs, and controls elections to Parliament, the state legislatures, and to the offices of the President and Vice President. He is also responsible for preparation and revision of electoral rolls for all these elections. It is his duty to see that the electoral rolls are kept up to date at all times. He is required to superintend elections to fill casual vacancies in Parliament and state legislatures. He is required to give his opinion under Article 103 and 192 when a vital question arises, whether of Parliament or of a state legislature, subject to any of the disqualifications. The Chief Election Commissioner also directs and controls the preparation of electoral rolls of states as well as the union territories and settles the program of work for them, orders the holding of by elections to fill up casual vacancies. He supervises the work of the chief electoral officers in states and union territories regarding elections. He examines the reports submitted by the electoral officers regarding filling of accounts of election expenses by contesting candidates and disqualifications of defaulting candidates. He considers and takes decisions on representations for removing disqualifications incurred by the candidates. He hears cases relating to recognition of political parties and allotment of symbols. He prepares the reports on general election and performs certain duties required under the Representation of the People's Act 1950 and 1951 and the rules made thereunder. He undertakes extensive tours for supervising the preparation of electoral rolls and conducts elections also and holds conferences. He also attends to administrative and financial matters pertaining to the Commission's organization and its functions. These are, in short, the functions of the Commission. Would it be possible for one individual to do full justice to the task assigned to the Commission, and can a single individual loaded with so many important duties present a picture of efficiency and impartiality? In my opinion, he can never. In this respect, it would be worthwhile to quote what the Joint Committee on Amendments to Election Law had said. It is a committee constituted by both houses of Parliament. It says that in order that elections based on adult suffrage in the country may be free and fair, it is essential that the election work should be spread and done throughout the length and breadth of the country, and that even in the remotest villages this work should be done in a manner so as to inspire the confidence of the people. The election machinery should be such that it may function effectively in every village, town, and city in an independent, impartial, and fair manner. Gradually, elections have ceased to be a 5 years affair but are held, if not every year, at least in every alternate year in some part or other of the our vast country. The elections have therefore become a continuing process entailing enormous work on the election commission. The immensity of the task of the election commission and the complexities of the duties it is called upon to discharge are too obvious and do not require any elaboration. It is too great a burden for a single person to exercise supervision, direction, and control effectively on the whole process of elections throughout the country. Stop.